Hi, everybody. Welcome. Good to see you all. I know it's close to exams, so thank you for coming. I'm very pleased to introduce today Oliver Butler, who is Assistant Professor at the Law School at the University of Nottingham, and he's going to talk to us about co-producing automated public decision-making. Oliver is a former student at the law faculty here. He did his PhD here and also undergrad, and also studied at the Universities of Oxford and at Harvard. He was called to the Bar of England and Wales, and I love when you read bios of people and you learn things. Called to the Bar of England and Wales in 2013, and also worked at the Law Commission as a research assistant on the data sharing between public bodies project. He was a fellow of Wadham College in Oxford, working at the Bonnevere Institute of Human Rights, and he has lots of work on sort of automated decision making, digital rights and regulation, and lots of very interesting but very difficult questions. And hopefully he's going to shed some light on delegation and the new machinery of government. Thank you, Oliver.
Thank you very much. Right, so yeah, good afternoon, everyone. Thank you very much for coming. What I'm going to be talking about today are the ways in which governments in the UK are increasingly using both augmented and fully automated forms of decision-making in order to either supplement their decision-making processes or replace them, and ask what problems that might pose in terms of preserving appropriate delegations of decision-making authority. So I'll be talking primarily about the principle of non-delegation. In administrative law, its purpose is to ensure that the delegatee that Parliament has selected is able to exercise those powers and only delegate that on where appropriate to do so. Your starting point when you're talking about the principle of non-delegation in administrative law is that Parliament gave you the power, not someone else, and so primarily you should be holding on to that decision-making authority. And underlying that are ideas around transparency, accountability, and ultimately contestability. If you're able to delegate things to third parties, you lose that transparency about where power lies and where it's been allocated. That in turn undermines your ability to hold those exercises of power to account. And in turn, that reduces your ability to contest them through political processes. But the principle of non-delegation has been subject to increasingly generous exceptions that mean that in practice, a very great deal of administrative discretion can be exercised by others on behalf of the primary decision maker. So as I'll talk about in more detail, courts have treated departmental civil servants as ministerial alter egos, which makes it very easy to delegate decision-making authority to them. That's especially important in hierarchical bureaucracies where caseworkers will make very large numbers of decisions using statutory powers. Outside, because of the classic Coltona situation, outside that, courts have still been very willing to imply powers to delegate for other statutory power holders, enabling them to delegate decision-making within their organisations. And there are some statutory vehicles for transferring functions to others, including to private entities. So the Deregulation and Contracting Out Act 1994 enables ministers to transfer statutory functions to others using orders. This was originally then a response to the changing administrative state. So in Coltona and Commissioner at Works, the court underlined the importance of this ability to delegate in terms of both a practical necessity, but also a constitutional appropriateness in the administration of the government of the country. The functions which are given to ministers and constitutionally properly given to ministers because they're constitutionally responsible to Parliament are functions so multifarious that no minister could ever personally attend to them. Otherwise, public business could not be carried on. So recognizing that practical reality that there would need to be delegation within the large departmental bureaucracies that developed from the 1940s in particular onwards. And its justification in part lied in the retention of constitutional responsibility on the part of the minister to Parliament in order to account for what was being done by those exercising the power in their name. And this led some to kind of make the case that non-delegation was a response to the changing machinery of government. And so that's the phrase used in the late 40s in Lewisham, London Borough Council and Roberts, in relation to this growth of the human bureaucratic state. And it goes hand in hand with this broader trend towards facilitating or tolerating greater delegation, driven by the perceived impossibility of maintaining non-delegation in light of the scale of traditional bureaucratic hierarchies. And it really struck me that this is strange terminology to use, the changing machinery of government, in an age where increasingly forms of machine learning are being used in order to augment or to replace traditional bureaucratic hierarchies. And so I wanted to ask a question as to, is the current law on delegation still apt for this emerging context? So the modern machinery of government, say supervised machine learning and various forms of decision support, what are the kind of key things that are happening in the modern setting in relation to that? Well, the Public Law Project conducted a wide set of FOI requests and research into publicly available information as part of its Tracking Automated Government project, which developed a register that was published in 2023 on the forms of automated decision-making that are currently in use by UK public authorities and governmental departments. They found 55 examples of these automated decision-making tools and evaluated them in terms of their transparency and presence of impact assessments for them, and found it generally lacking. So there's a background concern that this emerging machinery of government is occurring without adequate transparency and oversight. It includes policing, immigration, benefits, key parts of the central state. I think it's important to situate this in relation to broader controversies involving the use of algorithms by governments. I'm not suggesting that these particular problems were the direct result of improper delegation, but rather as examples of increasing concern about uses of algorithms by public authorities that cause various harms. So there's the Ofcol exams results algorithm in 2020, the moderation centre assessed grades during the COVID-19 lockdowns, which resulted in the downgrading of 39% of grades that have been awarded by centres, so schools, and was widely criticised for forms of indirect socioeconomic and other discrimination, ultimately reversed following public outcry, but underlining this concern about the rapid adoption of algorithms in ways that can cause harm. Before that, going back to 2014 or so, there was the TOEIC, the Test of English for International Communication Cheating algorithm scandal, which received further reporting in 2022. So this was a form of voice recognition technology that was used to listen to recordings of language tests taken by international students, which ultimately led to the obtaining of student visas, after reports by journalists that there was widespread cheating involved in taking of those exams. Now, the algorithm itself, according to some reports, flagged as much as 97% of the test results taken between 2011 and 2014 as fraudulent. And although not all of those resulted in visas being affected, some 34,000 student visas were affected in one way or another, and litigation is ongoing in relation to some of those uses of the algorithm to flag cheating. It's come under a lot of criticism for being a unrealistically high estimate of the prevalence of cheating, and subject to a lot of concern about how it was designed and implemented. And then another good example of these high-profile controversies is the gang violence matrix, which was discontinued in October 22. It was linked to over-policing, in particular of young Black males. It was criticised on a number of fronts around being discriminatory, about misusing personal data. It was ultimately subject to ICO enforcement action in 2018 and discontinued as a result. So there's increasing concern about the way in which these things are designed and implemented, and who's ultimately making important decisions about them. There are some good examples of important areas of government business being done using algorithms that come out of the TAG public law projects. So some examples of prediction algorithms that are used. The Common Risk Engine is used by DWP as part of its fraud and error risk scoring in relation to universal credit claims. So identifying those will be further investigated in that relation. The Home Office uses the modern slavery risk profile algorithm to profile potential victims and perpetrators of modern slavery. And in relation to local authorities, there's a use of a rent sense algorithm, which is predictive analytics for the risk of failure to pay rent by social housing tenants. So in relation to important areas of benefits of police work, of local authority housing, prediction algorithms are in use. And likewise, classification algorithms are also common in the TAG database. So there's prisoner categorizations conducted by the Ministry of Justice to give provisional prisoner categories for review then by prison officers. Project Alpha is a replacement for the gangs matrix in some respects, used by the Home Office, the MPCC and the Metropolitan Police for the identification of gang members using social media data. And a visa streaming algorithm is used by the Home Office as a classification tool, grouping people into green, amber or red to determine the grade of decision maker and the level of scrutiny that is then applied to visa applications. So in relation to prisoners, leasing and immigration, important decisions are entrusted to algorithmic classification. And the principles that we find then in the law on non-delegation adapt to this emerging use of augmented and automated decision-making. It's important to talk briefly about scope in relation to this. So I'm largely talking about forms of supervised machine learning. These are algorithms that are trained on existing data sets, testing data sets, and then applied in a fresh context based on the correlations that are identified by machine learning algorithmic methods. I'm not limiting myself either to fully automated or to augmented processes, so casting the net relatively wide here. Sometimes it will be the case that the algorithm is used in order to engage in decision support. So it gives a recommendation, or it gives a risk score, or it gives a prediction, which is then used by a human to continue the decision-making process. Sometimes you might find those fully automated forms where a decision is made on the basis of an algorithm itself. And I want to capture both of these because I think there are some problems with trying to draw strong distinctions between them when either an automated decision-making process ultimately has humans in the loop in its design and its application in choices about its implementation context. And what's important, I think, about all of this is that it's typically co-produced post-procurement by private developers in cooperation with public officials. So I'm not aware of any good examples of public officials designing these things entirely in-house. It's also relatively rare to have a purely off-the-shelf private product that is simply bought in. It's usually the procuring of a company which will work with the organization to tailor something to some degree to its needs. And that raises this question about to what extent are the public officials appropriately delegating important decisions about that to the private company, and can administrative law have anything useful to say about it? There are two features of that context that are important. So Sanchez-Grail's writing on UK procurement law has argued recently in current legal problems that procurement rules do very little to constrain the post-procurement negotiation and design of algorithms. And so we can't really rely on the procurement context on its own to solve these problems. And it's also an important part of the context, as Jennifer's written on, that there are complex and opaque supply chains around algorithmic processes. So it can be difficult to know what is within the control of the procured supplier and what is something that they in turn are using and buying from a broader supply chain. Many of you in the room will have a good understanding of what automated decision-making and supervised machine learning consists of, but I'll say a few brief things to set context for those who don't. So automated decision-making in this context can be used to produce a variety of prediction, classification, or optimization algorithms. And supervised machine learning is really a group, it really describes a group of statistical methods and approaches that can seek to identify sometimes quite complex correlations within data sets in order to supply predictions, make classifications, or optimize the distribution of a resource. By supervised, we mean that an initial training data set is used in order to train machine learning algorithm. It's supervised in the sense that it will be labeled by human labelers. So for example, if you would have a training data set that's labeled with approve or disapprove for a set of applications, and then the algorithm would look for correlations that explain what makes something one classification or another. Once it's been trained, and you might train a variety of algorithms using different methods against your training set, you can test those candidate algorithms against a testing data set, which is also labeled, and it enables you to form various measures of how effective the algorithm is at predicting the human labels, how accurate it therefore is, what level of confidence you can have in its predictions. And you can also test for different types of bias, false positives and negatives, and see the distribution of those. So it's possible, for example, to identify if false positive outcomes are concentrated against particular populations. So there's a lot of ways in which you can test and measure those algorithms before applying them to a live data set, which is the new context. Now, of course, there are lots of ways in which that process can go wrong, because the training data set may not be a good match to the testing data set, and the live data set, again, is a fresh context. So there are various also statistical measures of how similar the data sets are to one another that might inform the confidence in their outputs. So in the design process itself, there are lots of ways in which you can create measures of what might be a good or effective or a biased algorithm. And I think that's important, because that might point to some important design choices that we'd be worried about delegating too readily to the private company, rather than requiring them to be taken by an accountable decision maker. So the composition of your training and your testing data sets is something that could be scrutinized. The choice of different machine learning methods is potentially something that could be taken by the procuring entity. There might well be choices between different potential algorithms based on those measures of confidence, bias, false negatives, positives. And of course, it's an important choice as to what the deployment context is, how broadly you apply it, what weight you give it in its application, especially if it's an augmented technology that is supplementing, supporting human decision-making. And when we're talking about those sorts of choices, it's important to underline that they're not simply technical questions about the best method for applying an algorithm. They'll often involve trade-offs, either between different groups. That's especially important if you've got bias within multiple algorithms, or if you've got concentrations of errors in particular populations. And in values, there will be trade-offs between transparency, effectiveness, bias. And those sort of choices, therefore, are in that sense political rather than neutral technical questions. And this raises a question of what's the appropriate degree of delegation to developers, therefore, rather than trying to surface them in the space of political contestation. All right, so what role might administrative law on non-delegation play in relation to thinking about the appropriate delegation of responsibility between developers and procuring public authorities? Well, as the law currently stands, it's got some really quite severe limitations. So I want to talk about the main three of those that make this a very difficult tool to use in the context of the co-production of algorithmic decision-making. And this, in fact, was a disappointment to me, because my original intention for this paper was to tell you all how we might reimagine the doctrine of non-delegation in a way that fixed the world. But on reflection, it's got some really quite deep structural problems that I think make that difficult. The three key ones are that the current law on non-delegation focuses to a very great extent on the delegation of the final decision that's being made in relation to the exercise of the power. And that's a real problem if what we're talking about is an interim decision, recommendation, prediction that feeds towards that final decision. And it's also a problem if we're talking about fully automated processes where we might fixate on the final decision when there's still a lot of human input that goes in before it. The second major area is that there's a tendency to analyze delegation in this context as an all or nothing approach. You can either lawfully delegate the whole statutory power and all its component parts to another person, or you have to hold on to all of it. And that has some real problems when you consider ideas in the law around the inevitability of delegation being an argument for permitting it, and also the ways in which an all or nothing approach limits your ability to consider the seriousness of one of those composite pieces when you're thinking about the appropriateness of delegation. And then finally, the scope of non-delegation principles themselves feed into this problem. It's incredibly easy to delegate within departments or within departments that have framework agreements with agencies, but it's quite difficult to justify a delegation of final decisions outside those structures. And this makes it both over and under inclusive in different ways. So in terms of the focus then on the final decision, there'll be some who say this isn't a delegation case. So Lavender, Minister of Housing and Local Government, can be understood as a fettering, but it's the case in which one minister was not able to say, I won't make the decision without the approval of a second minister. And in doing so, they were held to have fully vetted their discretion, delegated essentially a veto outside the ministerial department. This was a focus on who had the kind of final say. And we see similar things in the broader case law on delegation and the notion of final decision is important. So in Ola Hinde, even though the court accepted that interim decisions would gather a momentum that's difficult to reverse and would therefore be the most important part of the decision-making process, the court nevertheless emphasized that it was only an initial decision, not a final decision, and that played an important role in saying that you could nevertheless delegate those decisions within immigration processes. Newnham Matthews expresses this quite well, that the case law in general is less strict if what you're talking about is not a final or conclusive delegation of authority. And that's a real problem if you're talking about non-delegation to augmented decision-making, which is precisely about interim recommendations or predictions, not the final decision. And on the other hand, it's potentially over-restrictive, fully automated decision-making, where because it is making a final decision, it's held to a much higher standard in terms of delegation. And overall, this might provide some missed opportunities to scrutinize those important design choices where important discretion is exercised, in some cases quite a distance away from final decisions. So the focus on the final decision is one of the key ways in which this area of law limits its ability to engage with algorithmic decision-making. The next is this all or nothing approach. So this is the way in which the case law tends to focus on whether the entire power may be delegated to another, rather than looking at features within that delegation. So in Coltona, they emphasized that the functions of the minister, if you like, as a whole, so multifarious that no minister could attend to them. You see an echo of that also in Ex parte Sherwin, where the courts emphasize that because no Secretary of State can personally do everything that's required of them, this becomes part of the argument for why they can delegate the whole of the relevant power. You see it outside the departmental context. So in Hoare, which relates to policing decisions, the courts emphasized that where the responsibilities of an office created by statute were such that the delegation is inevitable, there's implied delegation power. And they didn't look at that in terms of individual duties, but whether the overall weight of the duties and powers that fall on chief constables in practice was such as to make that inevitable. And this is something we see also in the immigration context, again with Ola Hinde, with the inevitability of a Secretary of State, or that it being obvious in the view of the court that the Secretary of State cannot personally take every decision, and therefore it was possible to delegate those decisions. All of this, I say, amplifies the importance of inevitability. If you're not able to divide a power up into its component parts, but you say it's all or nothing, then it becomes much easier to say that it's inevitable that you must delegate, because you're not able to separate out its component parts. This can be particularly worrying, I think, for ADM, because sometimes it's attractive precisely because there are large caseloads that you can't individually handle. But it doesn't mean that you couldn't take important design choices if you were to disaggregate the discretion that we're talking about. And that in turn, therefore, limits your ability to consider these important design choices, which might be of more limited scope than the entirety of the all or nothing power. It also reduces the significance of seriousness as a consideration as to whether delegation is appropriate or not. So if you had an isolated and vitally important matter, which was the language used in the Skinner case, this was on the accuracy of alcohol breath tests and whether the minister should have personally retained discretion to verify that the tests being used were accurate. If you're not able to focus on the isolated and important matter, it becomes much harder to talk about individual parts of the power being of greater seriousness. So although in the leading case now in Adams, they say that seriousness is a consideration to be taken into account, it did go on to comment on Skinner without criticism. It left this lawful delegation of an important and isolated matter to others, rather than insisting on it being taken by a more senior minister. If you're able to disaggregate, it's easier to say, well, these parts are of particular gravity and therefore should be retained, allowing you to delegate a remainder. And then finally, on the scope of non-delegation principles themselves, they're very permissive when it's delegation internal to government itself. So ex parte Sherman and Castle and DPP are the two examples where agencies could have functions delegated to them by a minister, subject to a framework document that in a very high level way ensured a relationship with the parent department. There are limited exceptions to that in the case law. So if there are personal qualifications to the individual who holds a particular power, this permissive approach won't hold true. That was the case in Birmingham Justices. And where the courts interpret a separation between two officials as being a safeguard built into the statutory regime, that will have a similar effect. So where delegation would conflict discharge a specific statutory duties, you wouldn't be able to apply such a permissive approach. So there are some areas where you're dealing with particular expertise of the office holder where this doesn't hold true, but in the vast number of cases, it's very easy to delegate within government. And that's reinforced by the level of scrutiny that then is applied to decisions to delegate within that. So in Chief of West Midlands Police and Birmingham Justices, the court emphasised that it was important that they delegated to a proper and appropriate agent rather than the proper and appropriate agent, and only applied essentially a rationality review to whether the right person had received the power, and an ex parte duty, a similar rationality test is discussed in the Court of Appeal. By contrast, it can be very restrictive if it's delegation external to government or in the absence of those framework agreements. In August, they emphasised that where there's a constitutional separation between two departments or a department and an office holder, this will be the case. And Lavender, I suppose, reflects a similar dynamic. And although there are some ways of operating outside that with ministerial orders, the Deregulation and Contracting Out Act, it's much more cumbersome if you were to try and relate to that. And it's not a great tool, really. It's very difficult for the minister making that kind of order to do a granular transfer within it. There's potentially an alternative approach in the case law. So Newnham Matthews is only a High Court decision. It relates to the Conservators of the River Cam and their prosecutorial authority in relation to the violation of bylaws relating to that river. The extent of delegation was in issue. So there had been a full delegation essentially to those policing in order to make decisions, and the argument of the parties was that overall policy should have been set by the Conservatives themselves. And the court agreed with this argument. They said they made use of a policy versus operational distinction. I've got some reservations about that sort of distinction and its ease of application to these questions, but it shows some willingness, at least at lower levels, to disaggregate a power. And in doing so, it was then able more easily to question the inevitability of the delegation of the high-level policy questions. And I wonder whether something in this might have a parallel that's useful for algorithmic decision-making, where you say, well, the high-level important design choices can be disaggregated from the bulk. So how then to preserve transparency and accountability in that space? Well, I don't have an answer today, but it's something I'm working on. There's a real difficulty in identifying with precision what the important design choices are, not least because the expertise to understand those decisions lies with the developer rather than the delegating public authority. That in turn means there are real questions about whether this is appropriate thing for the courts to engage with, rather than relying on other bodies to make decisions about important design choices. So I question, is it for the courts? Could it be for Parliament? Is there a role for statutory requirements in relation to some areas of decision? Is this a matter that actually is more appropriate for procuring entities themselves to consider and to develop more detailed guidance on? There is guidance for the procurement of algorithmic decision-making, but it's very light touch at present in the UK. And then perhaps to throw up the room, what might be the role for developers themselves in the future, engaging in responsible co-design with public authorities. There's not much discussion in the responsible design literature about what it means to engage with the public authority in order to ensure that key decisions are still subject to transparency, accountability, and contestability by those who are affected by them. So I'll draw to a close. I'm happy to take questions, but also to discuss more broadly. In fact, I'll leave that final slide up. If it's the case that administrative law on non-delegation is ill adapted to deal with this co-production of decision-making between private and public actors, how should we think about that, and where do the potential solutions lie? So I'll stop there. Thank you very much.